1 second. Okay. Welcome to Notable Approvals. Oh, not on. There we go. Now we're on Instagram. Okay. Welcome to Notable Approvals. I am Attorney Amanda Shaffer. I have another exciting case to get to today, doing a little slightly different format. I thought this case was a good example of a case to talk about when we are trying to make the decision of whether we are going to dismiss or not dismiss a case in removal or deportation proceedings. So today's case, I'll talk about a little bit, and then we'll go through some of the factors that were considered, some of the issues. And of course, if you're watching, thank you. And if you have any questions, please feel free to leave the comments, and I will try to get to as many questions as I can. So, a client is a native and citizen of Senegal. He first entered the U.S. in 2000 with a G is in giraffe, a G2 visa. G2 visas are for employees of either foreign governments or foreign organizations. So kind of similar to diplomats, they have certain immunities depending on their position. But it is different than entering on something like a B2 visitor visa, which is what his wife entered on when she came to the US in 2009. His wife was not on his removal proceeding case. So the client filed for adjustment of status based on something called LULAC, which does not exist anymore, back in 2006. So he had not left the country from 2000 to 2006. He got an advanced parole travel document. He left for about a month, came back, no problem. LULAC was denied, though. He was not eligible. I don't even know the details of the LULAC. I've never seen it. His application, I just knew he filed for it because he told me he had a travel document. I said, how'd you get your travel document? I filed for a green card. What was it based on? LULAC. A lot of people back then were filing for LULAC who were not actually eligible. So I don't know the situation with this client, but it doesn't help. I'll tell you that. We'll get to why in a little. So he then filed for asylum in 2012. And again, he didn't hire us until 2002 or 3. So if I were this attorney, I wouldn't have filed the application. The reason is he was not eligible for asylum or withholding of removal. Definitely not asylum because remember he entered in 2000 and there's the 1 year filing requirement that you file within a year of your entry. This was 12 years later. And his fear wasn't even based on himself. It was based on the fear to his U.S. citizen daughter. And if anything, mom had the asylum claim. Mom actually had been subjected to female circumcision, which is a valid asylum claim. However, she had never filed for it. I don't know why. My assumption is they went to this lawyer. The lawyer saw that the client had 10 years of physical presence in the U.S. and said you should file, and U.S. citizen children, and said you should file for cancellation. The only way to file for cancellation of removal is to be in removal proceedings. And you can try to ask the government to put you in removal proceedings, but they generally do not. That's why people file asylum applications. Sometimes you're not supposed to do it this way. We do see this happen a lot, and then people get put in some bad situations. So his fear was that his daughter was going to get circumcised if they went back to Senegal with her. And that was it. And then back when they filed for the cancellation of removal, that was the listed hardship for the daughter. Now, yeah, you need 10 years physical presence to get cancellation of removal. So that's why it's known sometimes as the 10-year green card, but that's not the only requirement. And we got to remember that. You also need good moral character And the most important and hardest thing is to show an extreme and unusual hardship to a qualifying relative. Qualifying relative in general can be a U.S. citizen or permanent resident, spouse, parent, or child. Sometimes it could be hardship to yourself. But if you don't have not just extreme and unusual hardship, then you don't have a good claim, and you're taking a big risk. Remember, this is the type of green card where there's only about 4,000 a year available, and right now I think the wait's up to like 4 or 5 years. So even if you win your case, you're waiting 4 to 5 years just to get a green card. So, as I said, in this situation, his daughter developed some type of illness in 2021. She was in the hospital for like 2.5 weeks. She got really sick. Thank you, Tom. Glad you found the info good. Thank you for watching. So she was in the hospital for over 2.5 weeks, and she had some really bad infections. There were issues with her heart. She was like she couldn't speak. There was a problem with her tongue. It turned out, I don't even know the exact diagnosis, which I'll get to why in a second, but something, and I'm going to butcher the name because I'm not a doctor, rheumatic chorea, I think. Now, if you look that disease up, you're going to get a variety of information. Sometimes it could be very serious, and sometimes it is not very serious. It all depends on the person. But what we did find out when the client told us is that his daughter needs to get monthly penicillin shots. If she doesn't, then she's very prone to infection. And in fact, at one point they had forgot to schedule one, and she went a few days too long without the shot, and she started to get really sick again. So there's no doubt that she needs it, and the doctor believes she's going to need it for years. Some people get it once, the shot, and they're good. Some people, this can last for 10, 20 years. You don't necessarily know it at the time. So when the client came to us, like I said, 2002, 2003, we were like, all right, well, at first we're like, there's not really a claim here. And then when we found out about the daughter's diagnosis, we said, okay, that puts this in the realm of a decent cancellation case. Now we need the evidence. So we said we need a letter from the doctor saying prognosis, diagnosis, and treatment plan. In the U.S., her U.S. doctor. We need if we can, get something from some doctor or someone that would know in Senegal to say, is penicillin even available there? Because if penicillin is not available there, then yeah, that's a big problem for his daughter. And some people might be wondering, what about medical records? Well, I have submitted lots of medical records to judges in the past, and I will tell you, they generally do not want to look through mountains of medical records. They generally just ask for that letter I described: diagnosis, prognosis, and treatment. And sometimes, the doctors even testify if necessary. So the client was able to get the letters from Senegal. Great. And got us a letter from the doctor here, but it was missing the prognosis. So it said that the illness she was diagnosed with, which I probably butchered earlier, it said that she needed the monthly penicillin shot, but it didn't say how long she would need it or how long she would likely need it, or this was a chronic or acute condition. It was really like bare bones minimal. So for the past year, we've been trying to explain to our client, this letter is not likely going to be sufficient. And we tried many times to explain, this is what we need. And despite thinking the client understood, he wasn't able to get us that letter. And in our last ditch effort, I wrote it down. I said, give the doctor this letter. Tell her this is what we need. See if she can testify. And of course, she was on vacation. So we were a little uneasy about that. And I also said we did have the hardship about the female circumcision. There was a caveat there. The couple, or more importantly, the client in this case, had a daughter that lived in Senegal still, that didn't come over to the US. And we had proof that she had not been cut. And so we'd have to explain, well, how is it that your older daughter has not been subject to this horrible practice, but your younger daughter will if you were to return, which is something that's very important. We were able, there was a good reason, but this was going to come down to credibility. Essentially, my client explained that he was paying one of the aunts to take care of his daughter and school her in another city, not in the village that they lived. And the wife, her family, also participated in that traditional practice and did not live far away. But he said, if I go back, I can't afford for my other daughter to stay with the aunt because you have to pay, and I wouldn't be able to pay. So I wouldn't be able to pay for both of them. And if they're in the village, there's nothing that we can really do. It ends up happening. But that was going to definitely be something hard to prove, but it was in their favor. When I was going through the documents in preparation for the hearing, I noticed that the client had a G2 visa, not a B2 visa. And that is an important factor. Why? Because, well, I'll say the old attorney just wrote visitor on the application, but then I saw his I-94 record. The reason it matters is because when you get to the border and you say, I want to enter the U.S., and you're not a permanent resident or a U.S. citizen, they ask you generally like what your purpose is for coming here. Either they ask you or it's inferred based on your visa type. When you're coming as a visitor, you say, I'm coming on vacation. I'm coming to visit a family or friend. That's fine. When you're coming on a G2, you're coming to work for the organization that you obtained the visa through. Well, I had to ask the client because I knew if I didn't, the government attorney would. Said, when you entered on the G2, did you continue to work for were you working for the organization? Did you continue? And he said, no. He said, I came then because there was an election in Senegal, the leadership change, and things weren't great. Well, that's a fraud and misrepresentation. And if the government attorney noticed that, it was going to be a knock against his good moral character, but not a huge knock, because I didn't dig into it more at that point, but we could have gotten into more about why he felt the need to leave his country at that point. And he did file for asylum 12 years later. But this is not that much worse than someone who enters the country like by crossing the border illegally. However, I also saw this LULAC issue. And as I said earlier, LULAC is an old form of relief from removal that got people a green card. Very specific circumstances I'm not going to go into. It doesn't apply anymore. But there was a lot of abuse of that system, and a lot of people applied for it just to get work permits or travel documents, and even though they weren't eligible. And even though the LA in LULAC stands for Latin America, you didn't have to be Latin American in order to qualify. But this client was obviously not Latin American, so there is an assumption he didn't qualify, but I didn't have to go into that. I just knew if it was brought up, the mere fact that he wasn't eligible is not going to look good for him. And then we were like, okay, well, your daughter, he also had a U.S. citizen son, but fortunately he did not have any problems that would lead to a hardship. We're like, your daughter's going to be 14 in a month. that means in 7 years she can file for you, for your green card. If we go forward today and we win, we technically aren't told we win. We just are told the case will be held open. It could take 4 or 5 years or more now for the green card. So now you're looking only at a difference of 2 years possibly. And then you have to remain eligible the entire time. So the easy way to say it is if you were to get arrested, now you might be inadmissible now, or you might just have bad moral character. But it also means that your qualifying relative who is suffering or who would suffer this extreme and unusual hardship if you were to be removed from this country has to continue to have that hardship. And because of the nature of the daughter's disease, and because we weren't sure if this was something that was going to last for a number of years or not, we were a little concerned, because what happens if in 5 years he's still waiting for a visa number to become available and the doctor says she doesn't need the shots anymore? Well, if the immigration court found out, then that would make him ineligible and they can deny it then. And then he would get an order of removal, which we wanted to avoid. So I spoke to the attorney for the Department of Homeland Security about the case, who was assigned to the case. And, I wanted to see first, get her input before we made a decision. So she wasn't convinced that the daughter could stay here without dad. It was clear the daughter couldn't go back to Senegal now with dad. It was clear that she needed a shot monthly, and that the shot wasn't available there. It was less clear to the government attorney about the female circumcision stuff, but we didn't even have to go there. But the actual condition that the daughter had, the medical condition, wasn't clear. The other issue was that when you have to show that your qualifying relative cannot go back to your country with you because they'll suffer an extreme and unusual hardship, but that they also can't stay in the U.S. without you due to this extreme and unusual hardship that they will suffer. And that's kind of where this claim really became difficult, because even though mom is here without lawful immigration status, she's a visa overstay, the government attorney said she could stay with mom. And I was like, yeah, but dad's the one who works. Like, mom works a little bit, like part-time, but dad's the one who earns all the money for the family. And this is something anyone watching this and thinking about their own case or someone they know, this is where things like this can really be important. Because you have to submit tax returns too. And she pointed out to me, she's like, your client is only showing like less than $30,000 a year on his taxes. She wasn't accusing him of anything, but basically she was saying it's not clear how he's supporting a family of 4 right now without government assistance. And we have to also report government assistance. The U.S. citizen children did receive Medicaid, and she goes, dad leaves the country, the kids still have their health care. That's not an issue. And yes, would it be hard for mom as a single mother with 2 kids? Of course. Would it be extreme? Yeah, I would argue it's extreme. Would it be unusual? That's really up for debate. I mean, compared to somebody similarly situated, it wouldn't necessarily be. Yes, it's nice for mom to have help, but the government attorney was like, "Oh, there's other government assistance." I'm like, it's not my area of expertise. So, ultimately, the client decided, after going back and forth, that he didn't want to risk it, because even if he won, or maybe he's saving 2 years with the green card, because it'll be only 2 years before his daughter turns 21. It was a huge risk that you're taking, and then once you know that the government attorney is that heavily against it, and the government attorney offered to have the case dismissed, to me, it's usually not a no. It's usually a no-brainer. For the client, of course, it's a lot more of a difficult decision. So, the point is, it was a totality of the circumstances. We had to look at everything, and so what I wanted to talk about just for the last few minutes is the factors that you should really look at when you're trying to decide, should I go forward with my case or not? When you have one of these cancellation of removal cases. And these are general things I'm going to talk about, so a lot of them can also be said to are good factors to use to evaluate other types of cases too, maybe asylum or withholding of removal, or other hardship cases. But since this case was about cancellation, we'll focus on that. So the first thing you really need to focus on is the strength of the case. Do you meet if you don't meet all the requirements and DHS is offering to dismiss, you take their dismissal. No questions, no ifs, ands, or buts. Then you got to look at the hardship element. That's really the element, because usually people don't apply for cancellation who don't have the 10 years. Usually there can be good moral character issues, but there's usually not too many. Like I said at the beginning, it all comes down to this extreme and unusual hardship. So you have to look at, will your qualifying relative suffer an extreme and unusual hardship in two situations? One, if you are to leave the country without them and they stay here. And two, if they were to go with you and to your country, will they have to suffer an extremely unusual hardship in both situations? We also have to look at, do we have adequate proof of the hardship? This was a rare case with a medical issue where I didn't have a lot of documentation. Normally, my clients give me too much documentation, which is preferable. I was very stressed about it. But if you don't, sometimes you can't get proof of something. If you can't, we explain it. But A, you have to try. B, you have to have a good reason. In this case, I do think there was a language barrier. I'm not sure I'm not sure what this client, what his level of education is. I know he comes from a remote village in Senegal, as does his wife. They both speak a little English, not much. But like I said, that's why we write things down as well. So we really tried hard to get the letter that we needed, and he came very close. But when it comes down to the day of trial, or really the deadline to submit documents, which can be 15 or 30 days, then, and you don't have exactly what you really need, again, that should make the decision a little easier if you can get the case dismissed. Then we look at, can the client adequately testify about the hardship? One thing I was struggling with these clients during the practice is I kept asking, what is the name of your daughter's medical condition? And they would say infection. Well, that's not the name. That's like I don't know if it's a symptom or a cause, not a cause. I mean, I'm not a doctor, but I know that wasn't the name of the illness that she had. And even though it's more important for them to describe the treatment and how it affects her, it does matter. Can you explain what this illness is? And that same goes with any type of learning problem, any social problem, whatever it is, whatever your child or parent, whatever your qualifying relative has going on. You have to be able to adequately explain it. In the alternative, you have an expert come in. And unfortunately, in this case, the expert wasn't available. And then you also have to look at any good moral character issues. As I said, this client had two things that could have posed an issue. It's how he entered the country and that application he filed in 2006. whenever DHS can say that they do not consent to approving the application based on good moral character, that's easy. They go for it. And it could really be a small thing. It could, and in all likelihood, this guy, when he, because I have so many clients who this has happened to, when he applied for LULAC, he did not know he was not eligible. He probably was told to go to an attorney, and the attorney said, yep, he's eligible, or a pseudo attorney, like a paralegal or notario. So you have to be very careful with these things sometimes because it can hurt you later on. But unfortunately, he signed his name to it, and that's what the court is going to see, and that's what the DHS attorney is going to go after. Then we look at what other relief is available. Is there any other relief from removal that we could take care of right now? If not, what about if the case is dismissed? Is there something that can be done? Now, usually, when we're asking this question, we're looking at a situation where the client has a U.S. citizen or permanent resident child, and it's just a matter of the child turning 21. Especially if you entered with any type of visa, then you don't have to leave the U.S. to go get your green card and come back. And if your child is anywhere near the age of 21, unless your case is so strong that we're sure you're going to get granted, why take the risk? Now, the one reason people take the risk, rightly or wrongly, is because they have a work permit. While all these applications are pending, they're able to get a work permit. And if you need that work permit for your job, you might be concerned about dismissing it because, like I said, it might depends how long until your child turns 21. I've had clients where we filed for prosecutorial discretion to dismiss their case when Biden first came into office, and their children are already 21, and they already have their green cards. I had one case dismissed for that reason, that even though it was a really strong cancellation case, by the time her number came up, because her place in line, her son was going to be 21 anyway. So why go the hard route? You can go the easy route if you can do it. How long the wait will be, I kind of just covered that with other relief available. So in cancellation cases is really when you're looking at the wait. For other types of cases, if your case keeps getting pushed off, because that's been happening a lot, because since the courts are so backlogged, if you're waiting 4 years for your individual hearing, maybe your U.S. citizen child is 21 by then, or maybe within those 4 years you fell in love with a U.S. citizen and got married, and they can file for you. And some people don't, even when they marry a U.S. citizen, don't want to go that route and do the filing. They want to do it on their own, which again, you could do, that's on you, what you want to do. But the question is going to be, is it worth going forward on the application before the court, or asking for dismissal, or agreeing to dismissal if you're offered? And then the other thing is, how much is DHS going to fight us? In this case, I mentioned earlier, I was informed that the trial attorney's boss was watching, and she was being evaluated. What does that mean? That means I have to expect a fight. So unless this case was so strong that it wasn't reasonable for her to fight on some of the issues, I could expect her to put on a show. I mean, her boss is watching. I get it. Nothing you can do there. But what the point is here is that these decisions sometimes can be really difficult, whether or not you request DHS to dismiss your case, or if you're offered it, whether or not you accept it. Especially when you have a case like this where you have some positive factors, a few negative. I think the positives did outweigh the negative. You do have, you're eligible technically, but you could still not win because, like I said, the bad moral character could have become a problem. And if my client were to get an order of removal because we lost today, then that would have meant when his daughter did turn 21, we would have had to get his case reopened for him to get a green card, and there's zero guarantee that that will happen. Right now, we are still in a time period where they are reopening a lot of cases. Um, that might end soon if there's a new president. It could even end with the same president. You never know. So if you're in a situation where you need to make this decision, and if you're not getting the answers you need or not having this explained to you the way I'm explaining it, well, our contact information scrolling across the bottom of your screen. We're here for you. Please feel free to reach out to us. And don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. If you found this video to be helpful, like Tom did, or you know someone who may, go ahead and hit that share button and save this so you can watch it again later. And, you know, you have to make the decision that's right for you, and you want to be confident in making that decision. So I wish you all the best of luck if you're in this situation. Congratulations to my client to no longer have to worry about this. As I always tell my clients at this point, stay out of trouble. Don't get arrested. This client never has. I don't expect that. And then in 7 years, you'll be applying for your green card. So that's all for today. Thank you for watching, and I'll see you next time.